of termination that you can have. There is with cause and without cause are the two main types that you're going to see. There are other situations, but I don't want to overcomplicate things. Without cause simply means that your employer is dismissing your employment and there's nothing really through no fault of you. So it's nothing to do with that you've done something wrong or that you've done you're bad in any way. For whatever reason, they are just wanting to terminate your employment. This is the most common way that employment ends for people, and so most often this is what you're going to see. Now, the thing is, when you get terminated without cause, in terms of your ROE that you get from the employer, it will just say that you've been terminated, you've been dismissed from employment. You will have to clarify with EI that whether it was for cause or without cause. Not sure why they do it that way. It kind of forces another step to have to clarify because EI will always have to investigate to determine the type of situation. But anyway, normally it will be clear that you're terminated without cause because your employer is going to be giving you notice that your employment's ending or paying out severance pay. All right. So this article will run through, I'm not going to read through this thing line by line. We have it here for people to read. This part here, we'll talk a bit about termination for cause and without cause. I've kind of already covered that. So termination without cause, what the employer will need to do is, depending on how long you've been employed, there is statutory pay, which means that there are in Ontario minimums and across Canada. Each province has a minimum amount of notice that employees must be given if they're terminated without cause. Those rules will change from province to province. It can range anywhere from 2 weeks to 8 weeks, but there will be, depending on how long you've been employed, you'll be entitled to a certain amount of notice just because of the statutory minimum. That means that no matter what your employment agreement says, they can't go below this certain amount of notice. So you'd be entitled to a certain amount of notice just by the statutes. Then, depending on your employment agreement, you might be entitled to more. If you have been, if your employment agreement does not limit you to the statutory minimums, then you can get common law notice, which will exceed in most cases the whatever weeks of notice are required under the Employment Standards Acts. There's a case. It's a case by case assessment. If you are entitled to common law notice, how much notice you'll get. It is definitely a case by case assessment. You can't really trust. There's online calculators. We've even toyed around with making our own. The problem is with these online calculators, they are not accurate. They're really just meant to give you a rough idea, but I find people really fixate on the numbers. And some of the numbers in these calculators, these are ideal numbers if everything goes your way. And they're not necessarily numbers that you'd be able to negotiate or resolve a case for without going to a full trial and having all the facts kind of come out in your favor. So just keep that in mind with these employment calculators. You really have to take them with a grain of salt. And I've had to explain to a lot of clients why it's reasonable to take this settlement, even though when they fill in this online calculator, it tells them all these extra months. So with the notice, you will get a certain amount of pay based on the weeks. And there's a chart in each province that sets out if you've employed X amount of years, you're entitled to X amount of weeks, Y amount of weeks. Okay. And in addition to that, most provinces will require the employer to continue to provide workplace benefits for the period of time of that notice. So if it's 4 weeks, then your benefits are supposed to continue for 4 weeks as well. One exception for Ontario, and I don't think it's not available in most other provinces. I think Ontario might be the only province, actually. They have a second tier, something called severance pay in their Employment Standards Act. Again, severance is often thrown around to mean a bunch of different things, but in Ontario, at least, severance has a legal meaning within the Employment Standards Act. It's another level of statutory termination pay that you're entitled to get. They call it severance pay. It's available only in certain situations where someone's been employed for 5 years or more, and the employer has a payroll of a certain amount of money. But in those cases, you are entitled to more weeks of pay, and it's important to know that. Most provinces don't offer that. You just get the straightforward termination pay, and that's it. All right. Some other things here that with termination, even if you're being terminated without cause, sometimes the employer there still can be what we would say kind of bad aspects to it, a wrongful. It can still be wrongful in the sense that even though they're saying there's no reason why they're getting rid of you, maybe there is a unspoken reason where they're not really saying, but you think it might be because you're pregnant, you're just coming back from a pregnancy leave, you're sick, you're just coming off a sick leave, that or some other discriminatory purpose is underlying it. Sometimes it's hard to prove, but even though the employer is paying you the minimum amounts required, if they have a discriminatory reason for terminating you, that is something that's not allowed at the law under the law. And so that is something to keep in mind. We do see that come up in some cases. Okay, this section goes through. Okay, here we go. This is, for example, shows you the. This is an example from Ontario that shows you if you've been, for example, employed between 4 and 5 years, you get 4 weeks. Again, you have to look at your own province. They're all different. This is just how it works in Ontario. Ontario has a very favorable one. Some provinces it's much less favorable to the employee. So things when I said that there are two types of notice you can get this minimum amount right here. You can also get the common law notice. The common law notice is going to look at when we're trying to figure out how much extra you get at the common. Nope. Sorry about that. We're getting an Amber Alert thing here. You still hear me okay, Maddie? Yeah, okay. So the other factors at common law, I said that you really can't rely on these calculators. The factors that courts will consider, there's a number of them, but four common ones are going to be your age, how long you've been employed, your type of job, how available is it for you to find other work like yours, given the economic conditions and that kind of thing. A rule of thumb that is thrown around is about 1 month for every year of service. So, for example, if you've been employed 4 years, you'd be entitled to 4 weeks of statutory pay. And if you use that rule of thumb, you could say, well, 4 months, because you've been at 1 month for every year, you could say up to 4 months of common law pay. Now, you wouldn't stack those on each other. They kind of go together. So it would be 4 months total, of which 4 weeks of it or 1 month would be statutory, and the rest would be the common law. Now, again, 4 months is just a rule of thumb, but it gives you a rough idea. So you're in a ballpark. It can be more or less depending on all the factors. Okay, I've already talked about severance and termination pay in Ontario. So how much money can you get? It's based on what your income, your weekly income was leading up to the time of the termination. Usually that's people get a regular paycheck. It's a little more complicated if your pay is not regular, where you get hourly pay and it's up and down all over the place. Basically, they'll look at averages over time and things like that. But otherwise, the pay is going to be based on it'll be gross pay based on whatever your gross pay is. So if you got 4 weeks termination pay, it's going to be 4 weeks of your gross pay. And from that severance pay, they will deduct your payroll deductions for, like, again, if you're continuing to get your medical benefits, it would be your medical benefit deductions, your tax deductions, EI, CPP, all those things. So it's really similar to just continuing to get a paycheck, but they just pay it out all at once. They'll take all the deductions off and give it to you. Now, the other pay you're entitled to at the time of termination is also any unused vacation pay that you still have. That will have to be paid out to you as well by that into that period well, they pay it out at the time when they're if you're continuing to work while you're getting notice, they'll pay it out when you're done working. If you're done working this today and they're saying here's your 4 weeks pay, they also have to give you your whatever vacation pay is out as well. Now we get a question that says, okay, if I've been terminated without cause, can I file a wrongful dismissal case? You can. So there's a couple ways that it could be a wrongful dismissal. The most common one is that they just have not given enough notice. Either they haven't paid you the statutory notice pay, or they're trying to limit your pay to the statutory notice pay of, like, say, 4 weeks, but really you're owed 4 months. So that is a way. It can be wrongful in the sense that they have not given you enough notice or pay instead of giving you working notice. So that is an area where many people will try to
go again, bring a case like this. The other way it can still be wrongful is if there is any kind of discriminatory nature or bad behavior on the employer's part, even though they're sometimes employers will do this thing where they really blame you and say that it's all your fault, but they will still kind of couch the whole thing as like without cause. So they will send mixed signals. Some employers just act poorly when they let people go and embarrass them, do things that hurt the reputation of the person being let go, um, do things that are just spiteful or upsetting. And all those types of things can result in higher damages in addition to the wrongful termination pay. So, what do you do? It's good to get legal advice in these situations. Unfortunately, with a lot of short-term employment, if you're being let go for without cause, you can't there are situations where you theoretically will be kind of entitled to more money, but it's not practical to get it because if you are let go and say they're paying you the 4 weeks, but you really could be entitled to 4 months. So there's 3 months there that you're not being paid for. The problem is if you get EI in the meantime, and if you have to hire a lawyer, by the time you pay a lawyer, the 3 months of pay you take off for taxes and payroll deductions out of that and pay back EI, like you literally will be into the negative, will not receive anything extra. So it's a lot of times we're having to unfortunately tell people like, yes, you could be entitled to more money, but if you qualify for employment insurance, then it's not going to be practical financially for you to go after this employer, at least not using a lawyer. By the time you pay the lawyer, pay the taxes on this money, and repay back the EI, there will literally be nothing else owed to you. So we kind of call it in house like it's a situation where we really just turn into a money collector for EI because we get paid as the law firm. The EI gets refunded. The government gets their taxes on the money, but the client would get nothing extra. So it's just not worth their time. The employer doesn't like it because they're still paying, even though all this money is going to these other sources. So the employer, if your goal is just to like get back at your employer, then I guess yeah, they are going to be paying out money, but you're just not going to see it all because of how it works. Now, if you have a longer term. So let's say you've been employed for 10, 15 years. Well, now that's a different story because of the amounts involved um, with the EI offset. Not always. It just depends on the EI offset and things and how much EI you can qualify for, but and how much higher your income is going to be over what EI pays out. So that's something lawyers will have to look at. It normally makes sense for people just to get the EI and just not bother with these lawsuits against employers. And we tell people that just from a practical point of view, it's just not worth it. But some people do want to go forward with them, especially if there's any issues that you can't get EI, then you definitely would want to do it. But it is something you have to keep in mind. All right, Maddie, I'm going to leave it there. I guess the last thing we have here is releases. So how this will often be presented to you, I'll say this in closing, is you will get offered, it kind of can come out of nowhere where your employer will say, we're letting you go. Here's what we're offering you. Please take it home and read it. And we would need you to sign it by Friday. And it's like, holy, like it's a lot of pressure on people to try to figure out what they should be doing. The key thing is don't sign anything until you get some time to think it over and get some measure of legal advice. Sometimes our advice to people is just go ahead and sign it because it's not practical for you to go after more. We've had clients where they don't want to sign it, and we say, well, that's your right. You don't have to sign it. If you're let go, the only way you can be made, well, you can't be made to sign a release, but if the employer, I guess the best way to say this is the employer, when letting you go, has to pay you the statutory minimums. So in the example we've been giving, they'd have to pay you the 4 weeks plus continue your medical benefits for those 4 weeks, plus pay out your vacation. They have to do that no matter what. They can't say that they'll only do that if you sign a release. Where a release will come in is if they're offering more than that. So they might say, well, we're going to pay you the statutory minimum. And if you sign this release, we'll pay you an extra 2 weeks. So some people will say 2 weeks. I don't even care about that. I don't want to sign this release. Other people will say, yeah, I'll take the 2 weeks and I'll sign the release. Now, just so you know, a release means it's a legal document that you sign that will, it has many functions. The primary function is to say that in exchange for paying this money to you, you will not bring another case against the employer for the same situation. So it means you can't sue them again. You can't now come back at them in a few weeks with a different claim, like, oh, well, that was for wrongful dismissal. Now we're going to bring a discrimination claim. So it basically gives away you're giving away, like, the employer is removing all liability for you as an employee, that any kind of claim is going to come up. These releases also contain other terms, so elements that make them also like a non-disclosure agreement. So there can be two to three elements to these releases. They can be a release of liability for the employer, which is the primary, but the secondary is they will secure non-disclosure, so that you are basically, once you sign these, you can't talk about it other than saying that it's been resolved. You can't talk about, they often will include non-disparagement clauses, which means disparagement just means like talking shit about the employer. You can't badmouth them. You can't go online and complain about them. Some of them will say you can't like advise other employees to sue them. So there's all these different clauses that are in there. And some employees, like I've seen some people give up a lot of money. Like just recently, I think an employee was being offered around $5,000 to sign the release. So they're paying 5,000 above and beyond the statutory minimum. But they would have had to do that to get the release. And the employee said, hell no, I want to be able to complain and badmouth these people the rest of my life. So I'm not taking that 5,000. I said, that's your choice. So that's what he did. All right, that's it, Maddie. I need a drink.
All right, let's dive into some questions. We've already got a few. Um, I've been terminated from my job without cause, and I was offered 4 weeks severance after signing the release. I also have benefits until the 4 weeks. I have unlimited vacation. I've been at the company for 1.5 years. It was only yesterday that I realized that my employment letter said I was not entitled to common law. Is this enforceable? Or are there other ways around it? I informed them that I literally just moved away from the city, although my role is remote prior to the termination. I have a deadline to review the letter, so I have to get back to the company soon. Please help.
Okay, I'm going to reread this because I was having some technical hearing issues, but I got the gist of it. So this is the kind of example of someone who's got one of these, like it's thrown on them. They're given a short period of time to figure it out. Um, Let me just see about this. So it is without cause. They're offered 4 weeks, which is the example we've been given. I have limited vacation. I've been at the company for 1.5 years. Okay, so 4 weeks would be more. That's more than the statutory minimum in every province, pretty much. So they're already being offered more than the statutory minimum. Um, the employment letter says I'm not entitled to common law. So the employer is asserting that this person has to not be entitled for common law. Your employment agreement has to say that you are not entitled to common laws notice of termination. This person saying, is there ways around that? Well, you'd have to have someone look at have a lawyer look at your employment agreement, and it will depend on the province you're in. Like for example, Ontario is the easiest province to get around like these terms in the employment agreement that say you can't get common law notice. Ontario is the province where courts have been most generous to people trying to get around these clauses. So you would have to have that looked at, um, and that'd be the only way. Often they're correct, but not always. There's certainly we have many cases ongoing right now where the whole gist of our case is that we're saying that those clauses that they have in their contract are invalid for one reason or another. There's many ways to invalidate them. I won't go through it all. And this person is saying, I informed them that I literally just moved away from the city prior to this termination. Although my role was remote prior to this term, I have a deadline to review the letter, so I have to get back to the. Yeah. It's hard to say. At 1.5 years, like without knowing all the details, if we just use our rule of thumb that you get 1 month for every year, so this person would be entitled to it just as a baseline idea, 1.5 months. They're being offered 4 weeks, so really, it's very close to what the baseline starting point would be to be looking at the situation. That's You're being offered likely more than the bare minimum. Probably the bare minimum in your situation is 1 to 2 weeks notice. They're offering you 4. They're saying that the rule of thumb with the common law notice is like 4 weeks. Sorry, would be 1.5 months or so would be the common law starting point. But it could go as high like depending on your job. If you're a manager, if you have a higher pay scale, then we could see a case like this going as high as 6 months. Okay. If you've been recruited and there was any kind of like disruption where you uprooted your life, then it could go even higher than 6 months notice. But likely you're looking at like 2 months notice, 1 to 2 months, 3 months notice in a case like this. And they're already offering you 4 weeks. So, but this is one where you need to get specific legal advice.
I've been on LTD for 5 years. I recently got a form from the insurer that is asking if there's been any changes to my contact information, income sources, doctor's name slash address, and date of last doctor's visit. Does this sound like the typical annual form that LTD sends for anyone that is on annual maintenance? Or does this sound like it's part of an upcoming larger claim review?
No, that sounds like a typical form to me. Their forms are all different, right? There's no like standard one, but there's nothing there that sounds out of the ordinary. Where these forms get kind of suspicious is when they're asking very, very detailed, like almost like a diary of your activities, like that they're wanting to know, like, what did you do give us over the last 2 weeks, list out your activity. That kind of stuff gets very suspicious because then you got to think they probably got surveillance, so they're going to compare what you say to what they have on surveillance. But this sounds like a typical annual form to me.
I mean, the severance is fully payable after I sign. I have not signed anything yet.
Oh, that was
That's
that
to
other
the
person?
first.
Yeah.
Yeah.
Yeah. So in your situation, I don't know all the details, but likely you're offered, if you don't sign the form, you'd get probably 2 weeks pay. And they're saying for an extra 2 weeks, you will you will give away all your rights against us and this kind of thing. So you have to decide if it's worth it to you to give up. Maybe you don't care. Like, I'm never going to sue them again. There's no other reasons. Um, but they're not offering a ton of money for you to give up your rights. But on the other hand, if you may not be entitled to a lot more common law notice, but again, a lawyer would have to really dig into your situation and figure out, are you someone that could be, are you someone that's likely only going to be off, like entitled to about 2 months, 2 to 3 months of severance, or are you going to be someone that could be like 3 to 6 months? But either way, it's not economic in a situation like you're describing usually to get a lawyer unless there's a lot of other factors that could push the damages a lot higher than just the 3 months or so of common law pay.
They just also make a note that they were let go yesterday.
Okay, yeah. Sorry to hear that.
They said they will pay me 2 weeks first and then 2 weeks after I sign the release. Yeah, I
Yeah,
think you went over that.
yeah, yeah. So it's 2 weeks. 2 weeks would be the minimum notice that they're required to pay. 2 weeks plus your vacation, if you had that. So ultimately, as someone in that situation, you just have to decide, is it worth it to get 2 more weeks pay in order to give them this release? Maybe you don't care, but once you sign the release, that's it. Where you got to be careful is if you also have an LTD claim, long-term disability claim, or anything like that, you have to be very cautious about signing these releases because some of them will try to basically outlaw you from making any type of claim or lawsuit against your disability insurance company. And you sometimes that's not intended, but that's how the releases are worded. So you have to be careful about that.
Work for a provincial government, Alberta unionized,
Yeah.
and but they back management. What is the difference of our rights when we are on long-term disability
Mhm.
between being terminated without cause, likely due to being on LTD, but they won't admit that, and when
Yeah.
they can terminate you due to breach of contract, like master agreement? I forgot the proper term was on the prior webinar. I.e., employees is on LTD just over 4 years and they want to terminate employment, so they no longer want to pay
Yeah.
LTD slash our pension.
Yeah. The word you're looking for is, um, What did we talk about last week? We talked about frustration of contract. So there's a different word for it in the union context. It's called innocent absenteeism, but they're the same thing. And what it means, so this just we'll just do the second part of this person's question first. So they're concerned about that once you're off work for a certain amount of time, an employer can fire you basically by saying you're incapable of doing the job because of your disability. So we're going to end the contract. It sounds it most people it says what that doesn't make any sense, but that is the idea of it. It's like you have an agreement to work for us, but through no fault of your own, you're not allowed to. You're not allowed. You're unable to do it. So we the contract, the employment contract just goes away. That's what the law allows. In a non-unionized workplace, it's called frustration of a contract. In a unionized setting, it's called innocent absenteeism. And but they're both the same. You can be dismissed from your employment without receiving severance. Now, I will say with a union situation, you always have to have someone go through your collective agreement because some of these collective agreements have severance clauses. Maybe they do pay for innocent absenteeism if someone is let go. So it'll all be in your whatever is in your actual collective agreement is what will apply. Now, what was the first part of this person's question? What is the difference between rights? Um, the problem with, well, not really the problem, but what's unique about government run LTD plans. So I don't have my book with me, or I would do my self promotion here. But in my new LTD book, which is called, it's written for people with group benefits. In one of the first chapters, I talk about the two types of group benefit plans. There's the normal insurance group benefit plans that most people think about. That's an insurance policy. That is that's the easiest to understand. The more challenging one, like this person, I think probably has, is a trust based LTD plan. It is not an insurance policy. It is a trust. A trust is just like a corporation. It's a type of corporation where a trust is set up. It's a type of, it's not really a corporation, but it's like an organization that is set up as a trust. So the money is in there, and this trust then adjudicates disability claims and pays out money. It's not basically a nonprofit system where the benefits are paid. It collects in the money and it pays out benefits. The problem with these trust situations is they can be very bizarrely organized, and your rights can be very curtailed with these trust plans. So with a lot of these trust plans, you're not allowed to do lawsuits. You have to just go with what the um, like the procedure that is set out. And it can feel very unfair because you don't have like people take for granted the rights that you have to be able to go to court. And unfortunately, people do take that for granted and don't realize the value of having the rights of being able to go to a court before a judge and have your civil or criminal, civil rights protected. When you get into these trust plans, it's all different. Like they do have to have a system that allows for adjudication and things and meets certain basic rules of fairness and that, but it is not the same as having your rights in court. The trade-off is that it's cheaper and faster, but cheaper and faster is not always better for you. It can be. Certainly the cheaper part can be, but fast is not always what you want because fast means you're rushed through to an adjudication without having all your ducks in a row and in the right information there. So the problem in these situations is you can run into conflicts with unions. I do support unions, and I think unions have a good role. However, they are organizations, and it's not always true that unions in every situation are going to be on the same side as any individual member. So, especially if an individual member has an issue that is just an irritant to the union doesn't want to deal with it or bother with it, then that's when you can get into conflict with the union. And that can happen in disability cases. But there are other times where unions will be very strong in helping people with disability cases. So I don't have a lot of, unfortunately for this person, I don't have a lot. I don't know about this specific union. Um, I don't want to talk specifically about your situation, but generally speaking, you will want to try to work with your union as best you can. And See if there are options to hire an outside lawyer, but that can be expensive and you may have to pay that out of your own pocket. So there's not really a whole lot of options. When you ask about what your rights are going to be what are dictated in the collective agreement. You don't have the normal civil rights that someone would have if you were dealing with a group insurance policy and they could just go to court. Excuse me, I just have a drink here. I'm in Fredericton, New Brunswick I literally just arrived in the room with Maddie calling me on my phone saying, "Where the hell are you?" I'm here for a conference tomorrow with lawyers from all over New Brunswick.
Yeah, you'll have to keep us posted on that. Give us the update next week on how that
Yeah.
conference went. Any new info. If given a termination letter of any kind, are you allowed to not sign it until discussing with a lawyer?
Yes. So it's in the employer's interest to have for you to review any of these things with a lawyer because once you review things with a lawyer and sign it, you're pretty much toast. So it by toast I mean you can't go back on it. If the employer is really concerned about they want certainty and they don't want this ever coming back from the grave, like you coming back and trying to sue them and saying you shouldn't have signed this release, like it's in the employer's interest to have for you to review with a lawyer. Now, some employers are just, to be quite frank, jackasses, and they don't want to give you time. They want to put maximum pressure on you to sign. Now, they do that at their own peril because those are the kind of releases that we can get clients out of. If you've been given 2 days or you're told to sign it on the spot, even worse, they don't really give you time to see a lawyer, then it doesn't mean that you would be let out of that agreement, but it is one that is more likely that you might be able to. So they they can't force you to like they can put unrealistic demands on you, like sign it before leaving the room, but that would never hold up in court, that type of a situation. Normally what happens is they give you like a week and people might procrastinate, they try to call around, they can't get in to see a lawyer within a week, so you can always ask for extensions. And as long as you tell them like I'm seeing a lawyer on this date, they're more likely to give you an extension. But if you're just saying I need more time with just generally, then employers will usually just say, nope, no more time. It's sign it then, or we're just gonna pay you the bare minimum, and then you've missed out on this other money.
Is it common for employers to issue a notice period of several weeks in lieu of severance, or do most employers just issue severance without a notice period? Wouldn't it be cheaper for employers to have a notice of termination period rather than pay severance?
Okay, so we're kind of conflating the terms severance and notice and all these things here. So I just want to make sure we're all talking about the same thing. Um, so I think what this person is saying is the difference between working notice and paying people out. So there's two ways this can work. Employers can tell you your job is going to be ending in 4 weeks. Keep working until then. And if you get a job in the meantime, that's great, but we'll keep paying you for the next 4 weeks, but you're expected to show up. The other thing is they say you're done today. Here's 4 weeks pay. See you later. This person wants to know why wouldn't employers just always do the working notice rather than paying? When they say severance, they mean like paying you out like all in one time. I think that's what this person is saying. Working notice only works when there is a good working relationship with the employer and the employee. So think about it. Like no employer wants a disgruntled employee sitting around who they fired. Also, if they want to fire you because they think there's something wrong or a conflict or anything, they would just rather have you out of the work environment. So there are different kind of those are the considerations. So the other consideration with working notices, it allows an employee to kind of leave on their own terms. When people are fired abruptly, even if it's without cause, the employer's not really able to talk to it with other employees. So the other employees are, oh, what did that person do? What's going on? Scuttlebutt, scuttlebutt. Whereas if you give someone working notice, they can leave at a certain point and it just, oh, they got another opportunity. They're going, they're leaving. So there are different considerations, but most employers will just go with if there's some bad thing going on and they're not happy with the employee, it's better for them just to terminate the employee and pay out the money right away and not have them stay. That would be the reasons.
And if terminated without cause or innocent absenteeism, are we then allowed to apply for EI? Because normally you can't get EI if you're fired.
Okay, so yes, you can always get EI if you are let go without cause. You cannot get EI if you quit or are fired for cause. So when you say fired, that's not quite true. So you can get EI if you're fired without cause, right? If you're fired for cause, then you can't get EI. What happens with EI is they have to investigate this. So even if the employer fires you and says it's for cause, like you did this bad thing, you said this remark, you insulted another employee, you said a discriminatory thing, you whatever, you did some bad thing and we're letting you go. We think you still might have stole money. Like they might fire you for cause, but EI will still investigate it. And if EI investigates and concludes that there was not really cause there, they will pay your EI benefits. So you should always appeal with EI and have them investigate because it is very hard to fire an employee for cause. Very, very hard. Smart employers and their lawyers know this and they will just not even go down that road. Because if you fire an employee for cause and it turns out it was not for cause, you didn't have proper grounds, you're into all kinds of other damages or aggravated damages, possibly punitive damages, because you have now hurt the person's reputation. You've made, usually with cause, you're making bad allegations against them. You've prevented them or frustrated their ability to get EI. So it just doesn't make sense for employers to try to fire people for cause unless they really are greedy and trying to, well, not really greedy. They're trying to save money and not have to pay the person anything, or they're trying to be spiteful to the person. So there can be over emotional sometimes with employers trying to fire people for cause. But smart employers and smart lawyers usually will steer employers away from trying to fire for cause unless they really have it paperworked well. Okay. Like some of the best cases for us to do as lawyers are ones where people have been wrongfully fired for cause. Those are our best cases when we get them because they usually involve like a disparity between a bad employer and an innocent employee. And so that dynamic makes it for a better legal case to take into court because you have a very good narrative in terms of good and bad. And there's a lot more money to go after. So it makes the case more financially viable for the lawyer and the client to want to pursue it.
This person's just asking about the book you talked about. I put it in the
Yeah.
chat if anyone else wants to download it as well. It's free.
Yeah. You can download a PDF copy. You can also fill out, if you download the PDF copy, I think it will give you the option to also order a paperback version directly from us. If you order the paperback version directly from us, we will send it to you for free. If you want to buy the paperback version, you can go on Amazon.ca and just type in David Brannen or long-term disability Canada book, something like that, and it will pop up. You can order it on Amazon too.
Someone here is just noting, edit, it is Canada Life. We have a long-term disability insurance through work.
Well, if this is the person through the Alberta government that you're talking about, just because it's Canada Life does not mean that you have an insurance LTD plan, because these trust-based plans that are not an insurance company, they hire insurance companies to run it for them. So on the surface, it appears like it is a insurance plan, but it is really not, because the insurance company is simply being a they're called a third party administrator. They're just administering it. It is not an insurance policy. You cannot sue Canada Life if they deny the benefits. You go through the plan's process for appeals. Now, I can't say that I don't know if this is exactly that person, and I don't know for a fact. I'd have to think about it, look at that Alberta plan to see if that's what it is. But just because there's an insurance company connected with it does not mean that it's an insurance policy. Just because you have other group benefits, like you have a medical plan, you got dental and all that stuff, that's covered by, say, Canada Life, it doesn't mean that Canada Life is also the insurer for the LTD plan. They just may be administering it on behalf of the trust.
I'm on LTD with an employer for over 2 years, working only part-time hours due to the disability. Is there a way to get a settlement on the LTD, perhaps from the insurer, so that I can go on my own as opposed to remaining with the employer? If I do not have a good prognosis for recovery, is that an option, i.e., to be settled and released from having to work part-time so I can focus on my recovery?
Hmm. If I'm on LTD with an employer for over 2 years, working only part-time, disability. So this person is implying or just saying that they're over 2 years, they're working part-time and getting LTD. That is already a very unusual situation because most LTD insurers are not going to pay people who are working part-time. So maybe you had this person has, I don't know if they're just talking hypotheticals, but if that is actually happening, I'll say, first of all, it's a very rare thing to have happen. It may mean that you have a unique type of LTD plan where it's an individual plan. That'd be the most likely how this would happen. If it's a group plan, this would be very unusual. So um, I would need to know a lot of facts around this. I do know that it is difficult to approach LTD plans about buyouts because their mind always goes to the fact that, oh, this person's going to go work full time. They just want us to pay them out, then they're going to go work full time. It is not easy to like convince them otherwise. Um, but they say they have a bad prognosis for recovery. Yeah. I usually like for this type of person, I don't know all the details, but I will just say that I usually counsel people to not try to get buyouts from insurers if you do not have a good prognosis. It is not usually a good idea. You're not going to get a good value of what's left in your policy. You'll get a fraction of the future value, usually like a third, quarter. It depends on your age. It can be very low what you're going to be able to get. And so it is usually not a good idea. Um, it sounds like this person maybe just doesn't want to work so they can focus on their health. Like you could have your doctor revisit whether working is right for you. Like maybe working part time is not the right thing. Maybe you should be off full time. You could explore that. But this is a tough one to answer without knowing a lot of details that I would not want you to give over this in this forum. Oh boy,
All
man, we're getting
right.
a lot of questions. Glad I
Yeah,
didn't have to
we
cancel.
We got one in the live stream, so I'm going to go ahead and read
Yeah.
that one. If an employee is expected to work in office twice a week, but is only coming in once a week, can this be used towards a with cause termination, or is severance still on the table?
So if you are not meeting workplace, so this is an example of not meeting workplace expectations or requirements, that can lead to a with cause termination, but you would need a warning if you continue to not show up according to what they're saying is the required, days in the office, this kind of thing. If you get warnings and not doing it, it can lead to a progressive discipline where you might get suspended for with pay, you get a warning, you get a suspension with pay. They can work towards a for cause dismissal. So repeated violation of legitimate workplace requirements in the face of ever increasing warnings and punishments can result in a for cause termination.
That's it for now. I'm going to look and see what we're talking about next week so I can let everyone know. All right, so connected to this one, we're talking about what you need to know about severance pay. So we'll be getting into that. If anyone has any questions about that or knows anyone who would be interested, just forward them this upcoming
So like
webinar.
severance pay in Ontario or severance pay in general?
Severance pay in Ontario.
Okay, okay. So severance pay in Ontario. Yeah, severance pay in Ontario is a very unique thing to Ontario. It is not severance pay in the general use of the word. There is like a in the Employment Standards Act of Ontario, there is something called severance pay. So we'll be talking about that.
Hmm.
It's very good benefit. It's great for people in Ontario. It's too bad every province doesn't have it.
Hmm. Yeah, severance pay is just one of those words I feel like it gets used so wrong all the time, and people just call everything severance pay. So it's kind of
Yeah,
confusing when,
it's not. Yeah, it's kind of like it's just a general word that is used.
yeah.
It's like to kind of describe everything, like severance pay. So that is how most people think of it. It's just generally used that way. But there's like technical legal ways it can be used that you just have to keep in mind.
Hmm. Will you guys be doing the same severance pay, et cetera, for all provinces, i.e. Alberta?
Possibly. We try to keep these webinars as broad as possible. Um, like it probably would not be of interest to enough people. Today we did Ontario, I guess, but we try to use Ontario as an example and then give other examples as well. But Alberta, we could do a session where we kind of go through the different provinces and talk about some of the big differences. Um, but there's more similarities than differences. The only real differences between the provinces, like Alberta would have its own table for what severance is paid based on how many years you've worked. Well, sorry, which termination pay is given under the act. But otherwise it's very similar to Ontario. It would just be the same, almost the same rules. Just would be a different table we'd look at. So if you've worked 4 years in Alberta, I don't know off the top of my head what it is, but you'd have to look at the table there and see how many weeks of statutory pay do you get. The common law is the same between the provinces. So that's really the biggest difference. And the only other difference with Ontario is they have this second tier of severance pay that you would not get in Alberta. All right. Looks like, Maddie, we might be at the end of our questions, which is good for me because I could use a little break. And we'll see people back here next week. Sorry we were late. I think it's the first time I've been that late on a webinar. Literally got road traffic, roads construction on the road, and then slow check-in at the front desk. And but anyway, we made it here, and I'm glad people stuck around. We'll see you next week, unless there's anything else, Maddie.
That's everything.
All right, folks. We'll talk to you next week.